This short video explains what a CQC warning notice, notice of proposal and notice of decision are and what they mean for a service. Care home support and training can help services who have received one of these notices, but it is imperative that you take swift action. You will see in this video how important it is to address the concerns raised by CQC and how seriously CQC take their enforcement powers. Services do close and providers and managers are prosecuted. The Health and Social Care Act 2008 Regulated Activities Regulations of 2014 introduced the fundamental standards. They came into effect for all registered providers on the 1st of April 2015. Regulations are more focused than the previous regulations, and some allow direct prosecution when the standards are breached. It is worth noting that CQC can directly prosecute for breaches of the Care Quality Commission registration regulations of 2009 as well. Where breaches of regulations do not constitute a criminal offence, CQC can enforce the standards by using civil powers to impose conditions, suspend or cancel registration. Failure to comply with the steps required when CQC use their civil powers is a criminal offence and so may result in prosecution. CQC protect people who use services by requiring improvement. This is through a requirement notice or a warning notice. A requirement notice is usually issued at the first rating of requires improvement. CQC will write to the provider informing them that subsequent ratings of requires improvement may constitute a breach of Regulation 17, Good Governance. A copy of this letter will be sent to the lead commissioner for the service. Services will be asked to complete an improvement plan, setting out what action will be taken and timescales for completion. An improvement plan is requested under Regulation 17 Part 3 and can result in direct prosecution if it is not returned within 28 days. Warning notices. CQC can serve warning notices when regulations have been breached. CQC can issue warning notices for breaches that have occurred in the past but have now been rectified, as well as in relation to continuing failure to comply with the regulations. CQC will set a timescale by when compliance must be achieved. If a warning notice is not complied with, CQC can prosecute or take action to vary or impose a condition on registration or take action to cancel registration. There is no right of appeal against a warning notice, but sometimes services can make representations to CQC about it. CQC can also protect people who use services by forcing improvement by using their civil enforcement powers. This is imposing, varying or removing a condition of registration, suspending registration, cancelling registration, or by using their urgent action procedures. CQC can seek an urgent change to registration, often cancellation, by seeking a court order. If a judge agrees with CQC, a court order will be granted and a notice of decision will be served. Providers have the right of appeal to the First Tier Care Standards Tribunal. If your service is rated requires improvement, CQC are warning you that your service is falling below the required standards and you must improve. Take this warning seriously. Ensure the actions that you tell CQC you are going to take meet the requirements of the regulations and that you will achieve this within the timescale stated. Failure to improve results in further enforcement action. Seek advice. Care home support and training are experienced and will support and advise you. If your service is rated inadequate, CQC is seriously concerned about your service and you are in special measures. Services in special measures will be kept under review, and if CQC have not taken immediate action to propose to cancel the registration of the service, it will be re-inspected again within 6 months. CQC's expectation is that providers found to have been providing inadequate care should have made significant improvements within this time frame. If not enough improvements are made so that there is still a rating of inadequate for any key question, CQC will take action in line with their enforcement procedures to begin the process of preventing the provider from operating the service. This will lead to cancelling their registration. CQC state that for adult social care services, the maximum time for being in special measures will usually be no longer than 12 months. If the service has demonstrated improvements when CQC re-inspect, and it is no longer rated as inadequate for any of the 5 key questions, it will no longer be in special measures. But CQC will continue to monitor intelligence they receive about the service until they return. Notice of proposal. If CQC are proposing to take civil enforcement action without following an urgent process, then they will serve a notice of proposal on the registered provider. This gives the provider notice of the action that CQC is proposing to take. Commonly, this is either to impose conditions on the registration or to close the home. Examples of notice of proposals: to prevent future admissions without the consent of CQC, to remove one of the regulated activities, to remove the location from the provider's registration, in effect to close the home, and to ensure the provision of information regularly to CQC. How does a notice of proposal become a notice of decision? CQC firstly issue a notice of proposal. The provider has 28 days to make representations to CQC as to why the notice should not be imposed. CQC will review any representations, or if no representations have been made, will adopt the notice of proposal and confirm it as a notice of decision. Providers can appeal to the first tier tribunal care standards against a notice of decision. Appeals must be lodged within 28 days. Care home support and training can offer a one-off mock inspection or audit. This may be the service you require if you want to check the progress you have made so far and to get an objective view of your progress. Quarterly visits to the service, including ongoing telephone and email support. Mentoring, support and training for managers, nominated individuals and providers on meeting the regulations and evidencing these effectively. And interim and crisis management, supporting managers and providers to address CQC enforcement action. At Care Home Support and Training, we are good at rolling our sleeves up and getting stuck in. You don't need endless action plans. You need help to embed good practice. Remember, if you're facing enforcement action, you should get help. Check out our website and use the online contact form. Give us a ring or send us an email. We look forward to hearing from you soon.